Well folks, the fight to free Tory Lanez is not going to stop until the day he's actually free. And until that day comes, our mission on this channel is going to be to show every which way that Tory was treated unfairly and railroaded through the legal system on his way to being sent to prison. And in covering all these different aspects of this case, I was sent a post by Angelo T over on X, which contained the complaint letter filed by Tory Lanez with the State Bar of California, where he is alleging that his original lawyer on the case, Shawn Holley, violated her ethical duties to him by not disclosing that she had close business ties with Roc Nation, the company that represents Megan Thee Stallion. And so I think this letter has a lot of good stuff about it and a lot of interesting stuff to talk about. And so that's what we're going to do today, is read through this letter together and talk about how this lawyer's potentially unethical conduct could have affected the outcome of this case. What's up everybody, welcome back to the channel. My name's Scotty O, aka the Gen Z attorney, and I currently work as a litigation attorney in North Carolina, where I work in both the civil and the criminal law. And on this channel I make videos about these high profile court cases and really just try and pull the curtain back to show y'all what it's really like inside the legal system. And as of late, the support has just been overwhelming in my coverage for this Tory Lanez case. So if you like it when I cover this case, then let me know by dropping a like down below. And if you like this kind of coverage generally, talking about these high profile cases, then subscribe to come back for more. Last but not least, I want to connect with y'all, so be sure to comment down below, let me know what you think about this letter, or hit me up on X and we can talk about it over there. But without further ado, let's jump into this complaint letter. So here we have it. This is the letter that Tory Lanez filed with the State Bar of California, alleging that his lawyer, Shawn Holley, his original lawyer, violated her ethical duties in her representation of him. So yeah, I'm not affiliated with Stake. I'm not affiliated with any gambling platform, so that's just part of the document. Just gonna have to ignore it. So yes, here we go. Subject, formal ethics complaint. Tory Lanez writing here, stating, I am making a formal complaint with the State Bar against my former attorney, Shawn Holley Chapman. State Bar number 136811. Ms. Holley was my former attorney in my criminal defense case, People v. Daystar Peterson. Attorney Holley violated her duties to me from the beginning of her representation to the time she abruptly withdrew, and in doing so breached her code of professional conduct as well as California law. Her representation severely hampered my case and set me at a disadvantage, which directly led to my conviction. So, this introductory paragraph kind of laying out, okay, who is who in this case, who is who in this issue that we've got going on. It should be noted here that attorneys are, even though despite, right, we have a reputation of being deceitful, being deceptive, it should be noted that we are all bound by the rules of ethics. And if we ever are caught violating the rules of ethics, then we are potentially risking a suspension of our law license or even the outright revocation of our law license. And so the rules of ethics are nothing to be played with. And every attorney has that in the back of their mind with everything that they do, thinking, is what I'm doing compliant with the rules of ethics? And according to Tory Lanez with this case, his attorney was not complying with these rules. So let's see why he is saying that. Ms. Holley's first breach of conduct was that she had a conflict of interest that she failed to disclose to me before agreeing to represent me. Briefly on background, I'm a musician and artist known as Tory Lanez, convicted in 2022 of assaulting another musician known as Megan Thee Stallion. I did not commit this crime or assault or harm Megan Thee Stallion. When I was first charged with the crime, I sought out Ms. Holley to defend me. I was referred to Ms. Holley by my entertainment attorney as an excellent criminal defense lawyer with experience representing high-profile and celebrity clients. After consulting with her, Ms. Holley agreed to serve as my defense counsel. A dollar amount was agreed upon, and I signed her retainer agreement. So far, standard, once again, more introduction of, once again, who's who, but as far as actually acquiring a lawyer, this is normal, where if you don't know a lawyer who specializes in what you need, so in this case he's charged with crime, serious crime, needs a high-profile criminal defense attorney that knows how to handle the spotlight, handle the media of a high-profile case like this. He doesn't know any personally, but he does know his entertainment attorney, who knows the business, knows the power players, and they are able to put him in touch with this defense lawyer, who is Shawn Holley. And so they meet, they consult, and they agree to representation and sign a retainer agreement. Now, we get into the good stuff. What Ms. Holley failed to disclose to me was that at the time she agreed to represent me and took payment from me, she was directly involved in a business relationship with the same company that had a business relationship with the alleged victim in my case, Megan Thee Stallion. That company was Roc Nation. At the time, Megan Thee Stallion was an artist signed and managed by Roc Nation. At the time of our consultation, Ms. Holley was one of the principal producers of a TV show titled Reasonable Doubt. Reasonable Doubt is a legal drama loosely based on Ms. Holley's life. In the credits of the show, she is listed as both a producer of the show and its legal counsel. The show first premiered in September of 2022, same year as and just a couple of months before my trial, which was in December 2022. The owner and CEO of Roc Nation is the musician artist known as Jay-Z. There are extensive ties between the show Reasonable Doubt, Roc Nation, and Jay-Z. The title of the show Reasonable Doubt is also the name of Jay-Z's critically acclaimed debut breakout album, and title of every episode bears the name of one of Jay-Z's biggest songs, which Jay-Z would have to clear the songs in order to be cleared. It also has come to my attention season 2 of the show includes music by Roc Nation artist and my accuser, Megan Thee Stallion. Apparently, Miss Holley has a daughter that is a backup singer to Beyonce, Jay-Z's wife. I was completely unaware of the show, Miss Holley's involvement with the show, or her involvement with Roc Nation at the time of the consultation, and Miss Holley never informed me at any time of her connection to Roc Nation. Miss Holley had a legal and professional duty to disclose her relationship with Roc Nation to me prior to agreeing to represent me and taking money from me or at some point thereafter. All right, there's a lot of facts there, a lot of information, but the main issue we're dealing with in this paragraph, this whole first section, is this notion of a conflict of interest. So bring this over to the American Bar Association. They are the promulgators of the rules of ethics. Rule 1.7 is their one about conflicts of interest and lawyer-client relationships. General principles. Loyalty and independent judgment are essential elements in a lawyer's relationship to a client. Concurrent, meaning the same, concurrent conflicts of interest can arise from the lawyer's responsibilities to another client, a former client, or a third person from the lawyer's own interests. So that's just saying that when there is a conflict of interest, it can jeopardize the lawyer's ability to represent both sides effectively, especially if both sides have an adverse relationship or are desiring adverse outcomes to each other. As a lawyer, you can't represent both sides because they both want different things, and they're usually mutually exclusive interests, meaning there's going to be a winner and there's going to be a loser, and so you can't be the lawyer that's both the winner and the loser. Jumping down to section 3 here, just talking about conflicts that exist before representation is taken, states that a conflict of interest may exist before representation is undertaken, which is what we're talking about here, right? Because we're talking about Shawn Holley already has a relationship with Roc Nation. That's conflict of interest based on them managing Megan Thee Stallion, and now Tory is the one who has been accused of shooting Megan Thee Stallion. So a conflict of interest may exist before representation is undertaken, in which event the representation must be declined unless the lawyer obtains the informed consent of each client under the conditions of paragraph B. What are those conditions? Resolution of the conflict requires the lawyer to clearly identify the client or clients, determine whether a conflict exists, decide whether representation may be undertaken despite the conflict, i.e. whether it's consentable, and 4, if so, consult with the clients affected under paragraph A and obtain their informed consent, very important. Confirmed in writing, also very important. The clients affected under paragraph A include both clients referred to in paragraph A1 and one or more of the clients whose representation might be materially limited under paragraph A2. That's a legal term of art there. When we're talking about representation and conflicts of interest, just because a conflict exists doesn't mean you're automatically precluded from the representation, because as you can see here from the rules, basically, conflicts are waivable. If everyone agrees and acknowledges, okay, yes, there is a conflict here, but we're all agreeing it's not going to affect the case. So basically, yeah, we're just going to agree it doesn't matter. It's not materially limiting the lawyer's representation in the case. Then we're good. But the key here is, right, when there's a conflict that exists prior to representation, the representation must be declined unless they obtain the informed consent of each client. This is not what happened here. You can see from what Tory is saying, when they had their initial consult, Shawn Holley never disclosed that she was working with Roc Nation very closely on this show that is based on her life. And this is not Tory's responsibility to try and figure this out. This is the lawyer's responsibility to look into the client that they're consulting with and compare their interests, their business interests, their personal connections to anyone that they're currently working with in a legal or business capacity and determine if a conflict is there. So yeah, absolutely, the lawyer dropped the ball here, and this is a serious issue, and explains why when we get to later in the case, we mentioned it already, she abruptly stopped representing him, because I think she got to the point where she realized, oh crap, this is a huge conflict, I can't proceed with this case, I'm going to get out of it. So moving on with the complaint, this conflict of interest and consequent breach of loyalty was exacerbated by the fact the person that assisted the alleged victim after the incident with medical care with the police and authorities and who spoke with and advised witnesses and or others involved in the incident with what to say to the authorities was a person by the name of Desiree Perez. Oh, we just made a video about Miss Perez, the CEO of Roc Nation Records. Ms. Perez apparently was even allowed to be present in the room with the police and the accuser when the accuser was being interviewed and gave other statements to the police. I have since been made aware Ms. Holley represented Ms. Perez and or Roc Nation or entities, private or nonprofit associated with Roc Nation, in legal matters prior to agreeing to represent me. I was not signed to or in business with Roc Nation at the time of the alleged incident. In effect, my counsel was in business with the same company that had a substantial investment with the person who was alleging I harmed her. I was unaware of these relationships at the time. I consulted with attorney Holley, and she did not disclose them to me. Instead, she assured me she could and would represent me to the fullest, and based on that, I agreed and did pay her between $200,000 and $300,000. Last payment that was made to her was during my trial on December 17, 2022, and on the very next day, December 18, 2022, she quit. So I need to go back and look at the exact timeline as to when the trial started exactly, when it started and ended. But yeah, this sounds about right. This is December 22. I know this is when the trial happened. I guess my main question is if she had any role once the jury was actually like in the box, sworn in, we're here, we're going, it's trial time. Did she have any involvement at that point, or did she jump ship maybe during jury selection or maybe during the pretrial motions? But if it's true, though, that she did jump ship mid-trial, yeah, you want to talk about prejudice to your client and violation of ethical duties. Yeah, this is insane, especially when you go through this paragraph and you look at just increased ties between Shawn Holley and Roc Nation and representing Desiree Perez and Roc Nation in apparently several different matters. For all intents and purposes, this is an attorney for Roc Nation. Yet here you have a defendant that is accused of shooting Roc Nation's golden goose, Megan Thee Stallion. And not only do you not disclose that, but you do a retainer and you take all the money and then jump ship. So yeah, this does seem to me to be a clear violation of the conflict of interest provisions within the professional rules of conduct. So I'd be very curious to see what the California State Bar has to say about such a high-profile attorney committing such an apparent grave violation. Now, the second breach of conduct is a direct result of the first. As a result of a conflict of interest, Holley did not represent me competently or diligently and actually worked against me. Real quick, that is another one of the rules of ethics, that every lawyer has an ethical duty to provide competent and diligent representations. So those are terms of art there as well. Those are specific words that are being used here to evoke that ethical rule, stating that she did not follow this rule and did not provide competent or diligent legal representation. So saying she did not do that and actually worked against me. First, during our initial consultation throughout the process, I told Holley I would not take a plea, that I was completely innocent and would not accept a plea that would imply or make me seem guilty of anything. But later, Holley told my DNA expert not to perform extensive studies on the gun so as to show I never touched it, quote, because she was going to have me take a plea. I was never going to plea, and consequently I had no evidence to produce at trial to contradict the district attorney's assertion it was inconclusive whether my DNA was on the gun. The absence of my DNA on the gun would have led to my acquittal. My understanding is that both the prosecution and the defense were able to offer DNA experts, and they both reached the same conclusion, which was that Tory was excluded as being the 90% primary contributor to the gun, but was found to be inconclusive to be one of the minor contributors, of which there was a 5% contribution, 3%, and 2%. So that's my understanding, is that the defense did have an expert who was able to testify, but basically they just reached the same conclusion that the prosecutor's expert reached. So any claims here stating that the DNA expert was ordered to not perform studies on the gun, or that the absence of DNA on the gun would have led to an acquittal, I don't think that's entirely accurate here. Now, as far as any statements that the lawyer made stating that, hey, we do not need to collect more evidence because he's going to take a plea deal, because, right, let's think about it this way. The only reason you would need all this really detailed, in-depth evidence would be if you're going to have a trial and you're going to present evidence to the court and a jury's got to hear the evidence and decide guilty or not guilty. That's when you need to do your really deep dive into gathering all this evidence together. I mean, it still is good to gather evidence, but if we're talking about like really every nook and cranny, that's going to be what you do in preparation for a trial. On the contrary, though, if something's going to be for plea, then you're no longer having to convince anybody or persuade anybody of anything, because you're acknowledging some sequence of events that you're pleading guilty to. You're saying, yeah, this happened and I'm guilty. Yeah, so maybe that's true that Shawn Holley was maybe not putting together the fullest defense based on her belief that he was going to take a plea. But once again, my understanding based on the 36 Hours Later website was that Tory did have an expert, a DNA expert, who testified and reached the same conclusion as the state's expert, which is a good conclusion for Tory. It's a good conclusion because how are we going to say he's the one that had the gun in his hand and shot it 5 times when the 90% contributor of DNA on the gun was definitively excluded as being Tory? That was that DNA. So he's not the 90% contributor. We know that for a fact. And it's inconclusive that at most he was a 5% contributor. It's inconclusive. We can't include it or exclude it. So the DNA evidence was quite helpful. But so yeah, I don't know. I'm not quite sure what he's talking about saying he was not able to put a DNA expert or have a DNA expert perform extensive studies on the gun. But anyway, During the process, I was repeatedly accused of violating the protective order that was in place. So right, when you have a case, especially a high-profile case like this, early on in the litigation process, parties can make a motion for protective orders, basically ordering parties within the case to refrain from certain conduct. Think of it in some cases like a gag order. If we don't want public statements to be made about the case, the judge can enter a protective order ordering all the parties in the case to not make public statements about the case. So that was entered here, especially in a case like this. I'm pretty sure it was a no contact protective order, just stating, right, Tory Lanez is not allowed to have any contact with Meg until the case is resolved. Apparently there were allegations that this was violated. The first time I was accused of rushing the stage at the Megan Thee Stallion show during the Rollin' Loud concert. At the hearing, Holley did not argue or demand the district attorney prove the incident occurred. No such proof existed because it did not happen. Cameras are everywhere and no camera showed me rushing the stage. I was temporarily arrested and had to be bailed out. Second time, okay, well, I guess let's address that one first. He needs to explain what the consequence was of, because right, he says he was accused of violating the PO by rushing the stage, and she didn't put up a good defense for him. But what happened here? Was he fined? Was he thrown in jail? Like, I understand he's saying here he was temporarily arrested, had to be bailed out, but that would have been the day of if he was, arrested at the stage. Assuming that's what he's saying here, is that he was arrested on the day of and had to be bailed out. If that's the case, then yeah, that sucks. But I don't know what she's supposed to do to fix that, because she can't go back in time. However, I do understand the frustration if she was not putting up enough of a defense to the accusation there. Yes, certainly that can be very frustrating. The second time, I was accused of violating the PO with a tweet that did not mention anyone's name, and only after being told by Holley the tweet did not violate the order. Again, I was temporarily arrested and had to be bailed out. Okay, that's more bad on Holley's part, especially if it sounded like she cleared the tweet. Only after being told by Holley the tweet did not. Yeah, so if he's told by her that he can make this tweet and it doesn't violate the PO, and then the court finds that it violates the PO and arrests him for it, oh yeah, that's piss poor legal advice. Like that's totally incompetent, not competent, and not diligent. Remember our terms of art. That was not competent, not diligent, and got him arrested. So yeah, that's horrible. If he really was acting on her legal advice, that the tweet was safe. Third time involved an incident in Chicago where I was accused without any corroboration of violating the order. The judge in the case said he did not see any violation, but my counsel, Holley, said to the judge house arrest would be okay. I had specifically told her when asked no, I did not want house arrest. As a direct result of Holley failing to defend me at previous bail hearings and for violation of the PO, I was subsequently denied bail upon conviction pending my appeal. Court said I had too many previous violations to grant me bail. Okay, so this kind of brings it all full circle now, because right, once he's convicted and he enters his notice of appeal, some judges can grant an appeal bond. Basically, right, you're still allowed to post the bond, get out of jail, and be out while your appeal is pending, so you don't have to sit in jail. Because what if you win the appeal, and say you win the appeal, but you spent 2 years in jail waiting for the appeal to go through? Well, crap, that's 2 years that you didn't have to do, that you, in fact, were not supposed to do, but you did them anyway because you had no appeal bond. So the fact that he was denied an appeal bond, and right, a judge does not have to grant an appeal bond, and so that's within their discretion. But when you've got the judge citing as the rationale for denying it here, stating, well, you violated all the protective orders before, so I can't trust you to be out on bail pending the appeal, so you're going to go and wait on your appeal in prison. Yes, that's not good, and especially specifically on this third claim, stating that he told her he did not want house arrest, but she's arguing that there would be. The client is the shot caller. The client is the one who has the final say over all the decisions that are made in the case. Think of it like the client is like the general manager of a sports team, but the lawyer is like the coach, where the GM tells the coach, like, here's the vision, here's what I want to do, here's my final say on what happens. But beyond that, it's up to the coach to actually implement the tactics and the schemes to ultimately fulfill the general manager's vision. And so yeah, once again, if nothing else, just the bad legal advice regarding the tweet. I'd argue that violates another rule of professional conduct here. So yeah, we're 2 for 2 here as far as potential violations that Shawn Holley has committed. Finally, and most egregiously, she withdrew as my lawyer during the course of my trial, leaving me scrambling to find new counsel and having any new counsel hands tied by the work she had already done. Her initial reason for withdrawing was a statement from one of the witnesses that Holley was trying to bribe her and affect her testimony on my behalf. This was never true. Then it became that she had another trial starting during my trial in Washington, D.C. Any calendar conflict she had or was going to have, notwithstanding her business relationship with Roc Nation, should have been known long before my trial started, and she should have withdrawn then. Instead, she took my money, barely offered a defense on my behalf, and then abandoned me in the middle of fighting for my life. Yes. Yeah, these are just some BS excuses here. You would know way in advance if you've got a trial scheduled, especially that same week. And if you did have a trial scheduled that same week, then guess what? You get a continuance on one of the two trials. You just say, look, because you're right, the judge is going to acknowledge you can't be in LA and DC at the same time. So one of the judges has to give you a continuance. So you just get the continuance on the one, you do the trial on the other. And either way, even if that was the case, that's no reason for you to just jump ship in the middle of trial. So yeah, that's but it's something I think I need to look more into. Once again, I'm curious about the timeline. If it was literally like we're already a couple days into the trial, now all of a sudden she's just like, yeah, I'm out of here, because that'd be really bad. Or was it like maybe during jury selection? But it's still bad, like still really bad. But there are gradations to how truly bad that her jumping ship could be and would be. So. The real reason she withdrew from my case is because she was unable to steer me into taking a plea to negligent discharge by admitting I shot the gun. I never did this, and it is my firm belief she was attempting to have me agree to this plea at the direction or urging of the people with whom she was in business with for her TV show, Roc Nation, who were also in business with my accuser and had substantial investment in her. My accuser had made numerous public appearances and statements accusing me of shooting her, and Roc Nation did not want her to be made out to be a liar and villain. Speaking of that, interesting how we've got a protective order here that is preventing Tory from, sounds like, speaking about the case at all. Yet we know Meg was going on Gayle King. She was going on national TV, talking about the case, talking about Tory and how he shot her. So once again, it's just this preferential treatment, this unfair treatment that Tory was receiving. But specifically here, the accusation is that Roc Nation was directing her to get him to take a plea. Maybe, but as the standard is, as we always see, as I always say on this channel, the standard is going to be show me the evidence. And this is something that the state bar is going to be able to get their hands on with the filing of this complaint. If they open an investigation, they can look into these ties and see, was there direction from Roc Nation to Shawn Holley to get him to take a plea. I would say, though, on the topic of taking a plea, if the plea offer here was to plead to negligent discharge of a gun, that's actually a decent plea for Tory to consider. Now, I understand his motive through this is, no, I'm not pleading to anything, I'm not guilty, and I'm going to prove my innocence. Especially considering, right, we look at the evidence here, and I can see under the most plausible theory of the case, which is that the girls were fighting, Kelsey grabbed the gun, she's the one who shot, and Tory went to try and wrestle it away from her. I could understand absolutely. He doesn't want to plead to anything based on that series of events. There is a pragmatic element to this, which is if you're being offered, because right, he was charged with assault by a firearm, and we saw the ultimate sentence here, which was 10 years in prison. Because right, that's a felony charge. There is this pragmatic angle of if he's being offered to plead to the lowest of the three charges, the negligent discharge of a firearm, especially if the offer is to plead to that and get probation, then that's not something you should just throw out if you know what happened, you know you're not guilty. Because old saying in the law, it's not about what you know, it's about what you can prove. And that's always going to be based on the evidence. Now, I've said a million times on this channel, y'all know I'm Team Tory. I think he should have been found not guilty. I can see why he wanted to take this to trial. But if this case doesn't prove that juries are just unpredictable and you never know what's going to happen, I don't know what case will. And so there's just always going to be that angle of, are you going to roll the dice with the jury and go for all or nothing? Or are you going to take maybe cut your losses, take the guaranteed hit, which it's going to suck, it's going to sting, but you're guaranteeing yourself to avoid the absolute worst of all outcomes. In fact, you're guaranteeing yourself an outcome, all things considered, is not that bad at all. So that's just something to consider here. If she was being directed by Roc Nation, absolutely, clear conflict. She should actually lose her law license over that and probably go to jail for that. But if we're just looking at her advocating or her trying to advise him that he should consider a plea, if I'm the lawyer here and I get this offer for negligent discharge and it's a misdemeanor for probation, then yeah, I'm probably advising as well. I think you should take this plea reduction. Now, of course, like I said, the client is the shot caller. He gets to make all the calls. If he says no, he's not guilty, we're taking it to trial. Then guess what? We're taking it to trial, and that's what happened here. But as we see, you roll the dice. Sometimes you lose. All right, to finish out this letter, to sum it all up, Miss Holley failed me as a lawyer. Bullet pointed list. She failed to tell me up front about her extensive relationship with Roc Nation, which was directly related to the person accusing me of harming her and possibly her daughter. She failed to tell me previously she worked with the CEO of Roc Nation Records, Desiree Perez, which had a substantial investment in my accuser. She failed to tell me she had done legal work on behalf of or with Roc Nation or entities associated with Roc Nation or principals of Roc Nation in some fashion. She failed, seemingly on purpose, to competently and diligently represent me. She told my DNA expert not to conduct the studies which would have proved I did not shoot the accuser. She failed to adequately defend me against allegations of violating the protective court order. And she told the court I agreed to house arrest when I did not. And finally, she withdrew from my case during the middle of the trial and did so for reasons that were not true. In the end, I lost my case and was convicted of a crime I did not commit because of the actions of Shawn Holley, whom I believe was acting either explicitly or by implication at the behest of or in the interest of Roc Nation. I want the return of the funds I paid Attorney Holley and the appropriate discipline to be imposed for her many breaches of professional conduct. Sincerely, Daystar Peterson. And yes, I'm glad I made my last video about the Demore Hadley lawsuit, where she's suing Desiree Perez for her use of all the resources at Roc Nation to manipulate the medical system and the legal system, because it does not seem beyond Desiree to put her thumb on the scale in this case, especially if she has a close relationship with Tory's literal attorney, Shawn Holley. Even if it's not explicit, like he says here, even if it's just by implication, then yeah, that's absolutely something that needs to be looked at and needs to be looked at closely. And maybe through this ethical complaint, the state bar can look into that, and they can actually evaluate very closely what was the relationship between Shawn Holley and Desiree Perez. And so yeah, all things considered, right, he's made basically two main arguments for ethical discipline. First being the conflict of interest and all the issues surrounding that. And second, the failure to provide competent and diligent representation. As you can see, those magic words again, competently and diligently. And so yeah, that is the letter that Tory Lanez sent to the state bar complaining about his attorney. Like I said, a lot of interesting stuff to consider there. I mean, we've got some discussion in about what it means to have a conflict of interest and what lawyers are supposed to do about that. The lawyer's duty to provide competent, diligent representation. And we also talked about plea bargaining. And remember this always, that it's not about what you know, it's about what you can prove. And even if you know you're not guilty, sometimes it is pragmatic and practical to consider a plea bargain just based on the evidence in the case. And the way I look at it when talking about plea bargains with clients is just telling them, look, okay, the bargain here is you plead guilty and you do a year in jail. But if you don't take it, then you're looking at, say, 10 years in jail. Let's say you reject it and you get convicted and you go to jail for 10 years. How are you going to feel on day 366 when you are sitting in your cell thinking about how you have 9 more years to do and thinking about, man, I should have took the deal? But yeah, like I was saying though, just really interesting stuff, especially seeing the close ties, the very close ties between Shawn Holley and Roc Nation, between Shawn Holley and Desiree Perez. We already saw the shenanigans that Desiree Perez was getting into with the Demore Hadley lawsuit, so definitely would not put it past her to try and get involved and manipulate this case in this way. So yeah, we'll see what happens with this complaint if the California State Bar decides to do anything about it. It is California, so who knows. So yeah, that's all it's going to be for today's video. So if you enjoyed it, if you learned something new, which I know we got into the weeds here with the rules of professional conduct, which some interesting stuff going on. So yeah, if you liked the video or you learned something new, then be sure to let me know by dropping a like down below. And if you want to see more coverage of the Tory Lanez case, covering all the different elements of it, then be sure to subscribe to come back for more. And let me know down in the comments, what other elements of this case do you want to see me cover? Because this video came about because I got a DM from someone on X. So I'm constantly looking for recommendations, constantly looking for interesting aspects to cover that y'all want to hear a lawyer talk about. So yeah, let me see what y'all got down in the comments. But anyway, if you made it this far, thank you so much for watching. I really appreciate y'all watching these videos all the way through, and I really appreciate the love and support seen in the comments and over on X. Y'all really do make these videos worth it. So yeah, thank you all for being here, and I look forward to seeing you all on the next one.